Welcome to today's webinar, Why is IP Important?, which is part of our series Getting Started with IP. My name is Fasiha, and I work in CIPO's Business Services branch in the Intellectual Property Awareness and Education team. Today we are going to uncover the basic concepts about IP, why it's important, and how it can contribute to unlock the value of your idea. Before we start, you might be wondering what CIPO does. IP rights are territorial and are managed by the IP offices of countries around the world. In Canada, it's us, the Canadian Intellectual Property Office, or CIPO, that is responsible for the administration of most Canadian IP rights. CIPO is part of the Government Department for Innovation, Science and Economic Development Canada, and we handle application guidelines, forms, and examinations used in the process to issue patents, trademarks, and industrial designs. We also work on increasing IP awareness among Canadians. So as I mentioned, we work to raise awareness for the effective use of IP by Canadians. To this end, our IP Awareness and Education program delivers a wide range of products and services free of charge to help Canadians better understand the importance of protecting and managing their IP assets. We are a team of content writers, presenters, and IP advisors who can assist innovators, creators, and entrepreneurs in better understanding IP before engaging in discussions with IP professionals, lawyers, or others where inevitably their IP will become a central point of conversation. Therefore, we have the resources to explain what IP is, how to identify your IP, how to protect it, how to manage it, and most importantly, where to find help. Our tools and resources are available on our website. We offer fact sheets, detailed guides, online learning modules, roadmaps, and more to explain the steps to register your formal IP rights. We also organize seminars and webinars, and it's possible to arrange meetings with our IP advisors either online or in person. So in today's webinar, we will attempt to answer the following questions. What is IP? Where and how is IP used? How do I know if I have IP? How can IP unlock the value of my idea? What are the benefits of IP? How do I manage IP? And who can help me with my IP? So let's start with an overview of what intellectual property actually is. IP is all around us. It's in the clothes that we wear, the coffee that we have in the morning, the electronic devices that we use every day, and in the music that we listen to on the way to work. IP comes from a creation of the mind. It's actually the form that an idea takes when created that can be protected. A few examples of IP include inventions, symbols, logos, pictures, designs, literary and artistic works, and many other representations. IP rights encourage innovation by giving creators the exclusive right to prevent others from stealing or appropriating their innovation. We find that most businesses have some form of IP, whether it's formally protected or not. In business, IP can set one's goods or services apart from others and is called property, because just like real property, rights are acquired with ownership. Like when you own a building or land, you can sell it, lease it, or keep others from trespassing into your space. Similarly, with IP, you can sell it, license it, and exclude others from using it. Also, like real property, IP is an incredibly valuable business asset. Here on the screen, you see traditional types of IP and the registered rights that are associated with them. Let's start off with trademarks. Trademarks refer to signs that distinguish one's products and services from those of others in the marketplace. A trademark can be a word, symbol, design, or even a taste, sound, scent, texture, or more. It's what consumers often first see and how they navigate in the marketplace. It's really about being distinctive so that consumers can easily identify a trademark with the associated product or service. Trademarks also include geographical indications and certification marks. Now, for patents, they apply to functionality and providing a technical solution to a given problem. They refer to the way in which you can protect new or improved products, machines, processes, and compositions. The invention to be protected has to be new to the world, useful, meaning that it must work, and inventive. There is also copyright, which typically protects music and artistic creations. Copyright is about original expression, creations that use some level of judgment and skill and are not just a mere copy of another work. Industrial designs, on the other hand, concern the appearance of an object. They serve to protect the unique appearance of a product and what appeals to the eye. This includes unique shapes and different patterns, and this can be on clothing, fashion accessories, technological devices, etc. And lastly, we have plant breeders' rights, which protect varieties and denominations of new plants. However, CIPO does not manage the application process for this. Instead, it's the Canadian Food Inspection Agency that takes care of those. So IP includes valuable information, and it's important to note that there exist other types of IP which hold valuable information but cannot be formally protected. A good example of that is a trade secret, which refers to any business information that derives its value from its secrecy. This can be a method, a technique, any know-how, research, analysis, data, a customer list, a formula, or recipe, or so much more. And it includes some sort of competitive edge, but that cannot be formally protected. Trade secrets are incredibly valuable. However, they may not be the best choice of intellectual property protection if your competitors can easily reconstruct or reverse engineer your creation. Reverse engineering is when you can recreate a product just by looking at it or seeing how it functions. There are other examples of non-traditional IP as well, like domain names and websites, which are typically confused as trademarks, but are actually not, and social media accounts that contain a lot of IP, such as trademarks, copyrights, and more. So now let's talk a little bit about how IP rights work together. Here is how most companies use IP. So most companies are based on some unique product offering, whether it's a product or a service, and that is their core business. Here we could be talking about a patent, a secret, or a way of doing something. Then there are a range of descriptions, so photos, manuals, websites, etc., to describe this unique offering to the public. Here we are talking about copyright. And copyright could also apply to the software or coding used by the business. And finally, often a brand or look of the product and service that helps consumers identify the identity or the source of the product and service can be taken care of through a trademark. These rights all work differently, and some require examination and time to get, and some are instant, so it's important to consider all of this in your ultimate business plan. It's not unusual for companies to rely on trademark protection all the way to the court while their patents are still pending, because trademarks are actually faster to get and protect the connection with their customers. Moreover, functional utility has a tendency to change over time, although patents are valid for 20 years, so the real economic value of a patent is often only extracted over a period of only a few years. By now, you may already be doing a quick mental audit of your current potential IP assets. When beginning to learn about IP, it's not always easy to correctly identify your IP and associate the right language to it. So, to help you out, here is our IP inventory checklist, which is a great tool to help you identify your IP assets. It is one of our most popular resources on our website, with its sleek design, plain language, and suggested next steps to take. It's incredibly insightful. Now, how do you think IP can be valuable to a startup business? We have the following options to consider. It can help attract investors and secure financing. It can establish a presence on online, commercial, and social platforms. It can achieve business objectives by being strategically integrated into your overall business strategy. It can fend off competition and secure market share. And it can build revenue sources. Of course, all of those answers are true. Intellectual property usually represents an important financial and legal asset for companies, including startups. For investors, companies with solid intellectual property portfolios are attractive investment targets. Protecting brand, innovation, and designs of the products with IP rights in major markets creates a basis for scaling businesses quickly and extensively. So that's a good reason for investors to love intellectual property rights. You can also use your IP to showcase your business on e-commerce platforms to make sales and to promote your business through social media platforms, of course with the goal of building your brand reputation. Protecting your IP with a registered right should be considered first priority. In the early stages of business development, leveraging IP is used to create a competitive advantage in the market. as well as driving revenues and profitability, which often makes a big difference. From a defensive angle, protected IP assets, through a registered right for example, is meant to discourage competitors from copying or using your IP in the first place. The inability of competitors to imitate a strategic component of another business's innovation is key to leveraging a long-term competitive advantage. Securing market shares is also possible when strategically protecting key IP assets, for example, through the limited monopoly provided by granting a patent. And of course, you can leverage the value of your IP to create a new revenue source, like licensing another person or company to use a patent or design in markets that you don't plan to enter. In fact, often a startup company's most valuable asset is its intellectual property portfolio. When used strategically in your business, IP can increase your competitive edge and become one of the most valuable business assets you possess. Competitors or partners can only use your IP with your permission, or they'll be exposing themselves to financial consequences. IP rights can also be used to leverage funding, and having exclusive rights to innovations is very attractive to investors because it means that there'll be up to 20 years of exclusivity in terms of the patent life. With that exclusivity, you can prevent others from making, using, or selling your innovation, and you can also sell or license your IP rights to others in order to increase revenue streams. You can sell or increase your IP rights to others, or you can use your monopoly from the IP rights to get a head start in the marketplace, all while building up a brand and a reputation. For all of these reasons, IP is incredibly valuable. So let's take a look at IP within the context of today's economy. Since 1975, we've seen a profound transition from a goods-producing model towards a data-driven economy, of course with the internet revolution in the 90s acting as a catalyst. The chart on the screen refers to the S&P 500. This is the stock market index that tracks the performance of shares from 500 of the largest publicly traded companies in the United States. In 1975, 83% of the value of the S&P 500 was in tangible assets, for example, in energy, materials, and utilities. However, today, intangible assets such as brands, information technology, communication services, and data comprise 90% of the S&P 500's total value. Promising technologies of tomorrow, such as artificial intelligence, quantum computing, and big data, are in line with the steady dominance of intangible assets in today's economy. What this means is that companies are investing less and less of their capital in plants, property, and equipment, and instead they are looking at new, intangible sources of value, and IP is the way to protect those. Now, in your opinion, is the following statement true or false? You should always seek to protect your IP assets through registered IP rights. The answer is false. As we saw earlier, some types of IP can be unregistered, such as trade secrets, and can be very important for a business, especially a startup which might have a limited IP budget. The costs of registering and renewing IP rights can escalate rapidly, so you may need to prioritize the formal protection of some, not all, of your IP assets. For example, a company that has developed a technology that could evolve rapidly may choose to opt for trade secrets rather than apply for patent registration, as the process is time-consuming and costly. IP protection is critical to fostering innovation. A company that owns IP rights will have a higher competitive advantage and legal protection against counterfeiting. Such legal protection is critical, in particular, for those companies that are wishing to export to new markets. For example, protecting the identity of products with a trademark and their appearance with a design is critical in the event of unauthorized use by a third party. Now you have an understanding of why IP is important. It's also important to stakeholders around you. That is also why you should care. If you're a small business, it's very important to protect any unique products or services that you own because competitors can use your success to take away market share, resulting in a slow growth or a loss of revenue. And of course, losing market share early on in a business development can be devastating and time-consuming if trying to chase up the guilty party without any legal protection. Here we have some 2019 statistics that show that there is indeed a positive association between owning IP rights and economic performance. We see that intellectual property can be considered a reliable protector of whether or not an SME will experience high growth. For all of those reasons, IP helps you stay relevant and competitive. SMEs have shared that their IP has contributed to their business performance by increasing their business value. As discussed briefly, IP offers you exclusivity in a market which increases your business value. As well, it can increase revenue, whether that's through licensing agreements, selling your IP. There are many ways to monetize it. It can also strengthen business prospects because, again, the exclusivity with which will increase your leverage on the market and create more business opportunities, whether it's domestic or abroad. And of course, business success means increased employment opportunities. So make your IP work for your business. Having IP rights is one thing, but it's essential to develop and implement an IP strategy to maintain them effectively. An IP strategy is a series of decisions and methods designed to maximize the contribution of IP to achieving your business objectives. First, an IP inventory. You begin by reviewing your IP rights and assessing their relevance to your business objectives. Again, you can use our IP inventory checklist mentioned earlier. Second, the freedom to operate. You should conduct an external review to understand the IP landscape, competitors, and market conditions. Third, you should have an action plan, where you analyze the findings from the previous step to identify risks, opportunities, and other issues. Create an action plan deciding how to use your IP to block competitors or grant licenses. Next, IP management and culture. So share your strategy with your staff and ensure that they understand their responsibilities for IP protection. You should manage risks, protect trade secrets, and consider non-disclosure agreements. Then we have the alignment of business goals. So you should regularly reevaluate and adjust your IP strategy to adapt to changes in the market with business goals and partners in mind. And lastly, maintenance cost evaluation. So periodically review the maintenance costs of your IP assets in relation to their commercial value. Of course, this process is cyclical, and the frequency depends on your company's size and IP portfolio. Keep in mind that there are numerous possible strategies and that there is no one-size-fits-all solution. Do what you can to make your business successful. Now, what do you think of the following statement? A business does not always own all of its IP. Is it true or is it false? This is true. For example, a business can acquire another company's technology through licensing to aid in advancing its own innovation. Or we can think of a mobile application, which is protected by copyright for licenses which are given to the public. It's very rare for a business to be the owner of all of its IP. Now let's revisit the establishment of an IP culture. You need to be clear first with everyone within a company should know that their position and responsibilities regarding IP are important. You should ensure that the various IP terms are specified in your contracts. And lastly, you should be clear about the process for internal and external IP disclosure. So in establishing a disclosure policy, this includes disclosure through the publication of documents or information accessible online, externally, or even internally through your company's private network. Create systems and routines to prove IP ownership, when and who invented, designed, or created what, and use a document tracking system to monitor who accesses confidential information, when, and for how long. You should also consider policies and education programs to raise awareness of IP within your company and the risks associated with neglecting IP, or specific education programs to develop or integrate IP skills for all employees, contractors, advisors, where IP is related to their professional outcomes. As well, you should educate your employees to ensure that IP-related policies are reflected in their employee contracts and all training materials. And lastly, determine who will conduct IP research and monitoring, and when and how. This will depend on the size of your company and your IP assets. As we've seen, investors often look for unique innovations that can either be protected and monetized by a proven business model. So they need to be reassured before investing. And for this, they may look at, is your IP strategy aligned with your business goals? Do you have a forward-looking plan to capture valuable IP in your industry? If you want to enter foreign markets, do you have a plan? And your competitors, could they accuse you of infringement? Now, for my favorite slide, let's take a look at common IP mistakes. First, let's start with waiting too long to start protecting your IP. The earlier you protect your IP, the lesser your chances will be of a competitor beating you to the punch and ensuring that your rights are taken care of and preventing infringement. Next, losing IP because you don't understand you have it. That's where the importance of planning an IP strategy where you do an internal audit of the IP assets you own so that they don't slip through your fingers without you even knowing you had them is critical. Number 3 and 4 go hand in hand. Infringing on someone else's IP and not knowing it, and performing insufficient research on your competitors. You must do your homework and make sure that no one else possesses registered IP rights that are identical or similar to yours. There are databases available on each country's national IP website, so don't hesitate to seek the help there or of an IP agent or lawyer to assist you in those searches, especially patent searches as they can be more complex. And 5, finally, refers to facing IP ownership issues because you don't have the proper contracts and agreements. It's important to be preventive rather than reactive in IP matters. When it comes to work contracts, for example, it's important to ensure that there are specific clauses which address IP ownership and that you're aware of those clauses because in many work relationships, any IP you generate will not be owned by you, but will be owned by your employer. It's something that you should address in a contract, and it's also very important to address IP ownership in any collaborative endeavors like partnerships, because IP ownership issues often arise in those contexts too. Basically, it's important to never assume that you own your IP and to take the steps needed to consult legal professionals to assist you in the drafting of proper contracts. Here we have additional tools that we offer on CIPO's website to assist you in getting started with intellectual property. Of course, there is the IP inventory checklist that we've spoken about earlier. It's there to help you do an internal audit of your IP assets and to find out what type of IP you might already own. Then we have fact sheets that provide general basic information on each type of IP, such as what is a trademark or what are trade secrets. Then we have the e-learning modules and the IP strategy self-assessment tools to go a little more in depth, and these can help you get started on creating an IP strategy for your business. So all of the resources, materials, and tools that I've talked about contain a wealth of useful IP-related content and are available in different formats on our website, including audio, video, text, and interactive. We are happy to guide you and give you as much information as possible on IP rights, but unfortunately, we cannot provide you with legal advice. All of the questions that you see on this slide are unfortunately questions that require a legal opinion. And you might find that you also need help in understanding complex topics, obtaining other legal advice in case of infringement, or seeking an opinion on strategic positioning and searching advanced databases. To that effect, there are groups and associations of IP professionals that you could turn to. To locate a licensed IP agent near you, you can contact the College of Patent and Trademark Agents, or CIPATA, which is the newly formed organization responsible for the management of IP agents. We recommend that you deal only with the IP agents that are on the CIPATA list of registered agents. These are individuals that have passed IP-related exams, are regulated, and disciplined by the CIPATA. Unfortunately, there are individuals out there who will pose as IP experts despite not having the required credentials, so it's important that you stay diligent and that you consult the CIPATA website to make sure that you know who you are hiring to assist you with all endeavors related to IP. And we also have the Intellectual Property Institute of Canada, or IPIC, and the Bar Association that are professional associations where you can look to find a lawyer or more IP professionals. And please do not hesitate to contact us if you have any further questions or need help finding any of the resources mentioned on our website. You can reach us via the contact information that you see on the screen. You can also contact our intellectual property advisors for more specific and tailored discussions to your needs by scanning the QR codes here. As well, for general questions about IP, you can reach out to our customer service center by phone or by email. The toll-free number is also provided on the screen. And I invite you to follow us on social media. We are on many platforms such as Facebook, YouTube, LinkedIn, and X. Finally, I also recommend exploring the CIPO newsletter titled IP for Business News, where you can find more information about new IP products, seminars, webinars, upcoming events, and updates to the CIPO website. So this concludes our webinar on the importance of IP. I hope you have learned more and enjoyed this presentation. To learn more about the topics related to intellectual property mentioned before, I invite you to watch our other videos and register for our live webinars on our website. Thank you so much for watching.